Thank you, Mr. Chairman, for holding this important hearing, and thank you to all of our witnesses for appearing before the committee today. The Supreme Court's recent decision in Loper corrects decades of regulatory overreach by the executive branch and rightfully reasserts the separation of powers as intended by the framers of the Constitution. It ensures that the will of the American people is heard through laws written by their elected representatives. As a former judge, I agree that the power and responsibility of interpreting the law belongs to the courts, not unelected government bureaucrats. The clearer the law, the easier it is for judges to faithfully and accurately apply and interpret the law. Congress, therefore, has a renewed call to assert its legislative authority and write clear and precise laws. Dr. Kosar, I'd like to begin with you. You have written extensively about Congress establishing a congressional regulatory office, which would likely be a longer-term project for us to undertake for the interim, or in the case where Congress chooses not to establish a permanent office. How can Congress strike a balance with its role in the rulemaking process that leverages agency expertise while maintaining strict legislative oversight and accountability?
Well, in the short term, if you can't get the purse strings loose enough to do a little pilot, say within the CBO, to test it out, particularly say within an issue area of real concern, you can try to draw upon the existing legislative branch folks more aggressively. I spent 10 years at the Congressional Research Service. I don't recall once in the thousands of requests I got a member saying to me, hey, there's this proposed rule in your issue area. What do you make of it? Can you at least write me a memo and explain to me what this means and whether I should be concerned about the extent of the regulation, whether it's proper? That would be one means.
And you just touched on what I really was interested in as my next question, which is how can we better facilitate meaningful collaboration between lawmakers, legislative staff, and then agency experts to really draw upon all of that collective experience during the legislative drafting process?
Yeah, the drafting process. Well, I think the drafting process in many instances has been bedeviled because there's not a regular order being followed. Bills are being slapped together with a lot of other bills. You guys are being called to the floor and told it's time to vote on the rule and please line up by party and don't scuttle things. Reorienting, getting back to a more regular process where committees are in the seat, and when committees report out a bill, those things get preference on the calendar, would allow a process by which you could be more deliberative and you could draw more on the expertise that's already available to you and get it in there.
Mr. Cruz, as you know, in 2023, the Biden administration released Executive Order 14094, which raises the threshold for which regulations are considered highly significant and drastically increased regulatory costs. How would you compare the Biden administration's approach to regulatory action with that of the previous administration?
Well, the Trump administration was defined by basically a regulatory cost budget. The one in, two out mechanism put that into place, and according to the data released, it worked. You could say there was low-hanging fruit there, and once you got rid of some low-hanging costly regulations, it was hard to do others. But things have changed with respect to Biden in the sense of we used to consider a regulation economically significant if it was $100 million. That term has completely disappeared. If you go onto the OIRA website now and go to the database of rules and regulations in the Unified Agenda, the term is completely wiped out and it's replaced with Section 3F1 significant rules. It's not as poetic anymore. But you can still find those $100 million major rules purely thanks to the majorly bipartisan Congressional Review Act. So you guys still have something that you can sink your teeth into with respect to tracking major rules and some of these other projects you were indicating with respect to looking back. And I can tell you the new Unified Agenda came out late again, as we were discussing earlier with the new Unified Agenda came out, and you would expect that with 200 million threshold that the numbers of rules would come down a good bit that were at S3F1. You would expect that to occur, but no. in this current push, you know, the CRA gives an incentive to an outgoing administration or potentially outgoing administration, because it's an election year, to jack up the number of rules, and that's exactly what we saw. So in the new unified agenda, there's a big jump in $200 million rules above what you might have expected, but you still need to monitor the ones that are beneath that level as well.
Thank you, Mr. Chairman. I yield back.
Gentleman